673. The law office is open. And now your host, Patrick Smith.
Oh, hi there. Happy Saturday morning. Welcome to the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith, and we are here with you live for the next hour. Questions. So you've been out there all week. Life's thrown you a series of curveballs and different developments, sometimes good, sometimes bad, and they produce legal questions. Well, we're here to help for the next hour. You can call in now, toll free, 877-943-9673, 877-943-9673. Open phone lines. We will get you and your question right on the air. Again, I'm local Central Florida attorney Patrick Smith, here with you for the next hour to help you on any legal matters that you may require assistance on. And your legal question can be on any topic at all. Sometimes they're landlord-tenant issues, property rights issues. Sometimes we have family law matters come in, Medicaid planning for elderly loved ones, and estate planning topics. Sometimes they're personal injury questions. A wide variety of questions come into the show, so no question off limits. We're happy to help you any way that we can. 877-943-9673. You can email your question also by emailing it directly. Patrick@attorneypatricksmith.com. Patrick@attorneypatricksmith.com. And as always, our wonderful intern, Peter the intern, with us in studio to answer, or rather read out. He's not going to answer them yet. Doesn't quite have that law license, but he's working on it. So he will be here reading your email questions to me, and I will give them the very best answer that I can. So again, you can email your questions, Patrick@attorneypatricksmith.com. And you can also call in now, open phone lines. We will get you and your question right on the air. 877-943-9673. 877-943-9673. That's your toll-free number to be part of today's show. You can call in and we will do our very best to help you as best we can for the next hour. So 877-943-9673, or email your question, Patrick@attorneypatricksmith.com, and we will do our best to help you. So, and also in between calls today, we're going to talk about lots of different interesting topics that came up during the week at the law office. But first, let's go to Tampa and talk to Virginia. Virginia, welcome to the Attorney Patrick Smith Show. How can I help you today?
Hi. Thank you, attorney. I appreciate your time. I just wanted to ask you about, I was working for this man who owned some hotels, and so I was working about 70 hours a week. He'd send me to Bradenton and Sun City Center, but I wouldn't get overtime. And so when I asked them why I'm not being paid overtime, he said, well, I'm using two different tax IDs for Sun City and for Bradenton, and I don't get overtime because I have two jobs with him, which is not what I agreed to. And so I told him, well, I can't work 7 days a week anymore for you. I need the weekends off because I found another job that pays, more, and I need to spend time with my family. I have no time for my daughter. She's behind in school. And he said, no, you're fired. If you can't work 7 days a week, you're fired. So I was just wondering what my options are for him not paying me overtime.
Wow. That is a fantastic question for so many reasons, Virginia. Thanks for calling in with it. It reminds me, a buddy of mine handled a very prominent company's IPO. And when he was in the middle of it, he said, we have to be very creative when it comes to IPOs. And he says, but it's also walking a very fine line. He said, one side of the line, it's a successful IPO and I get a huge bonus. The other side of the line, I get something called a federal indictment, and that's bad. So it sounds to me like this particular employer is trying to be very creative with the multiple tax IDs and saying, you're not really working full-time for either corporation. Specifically, it's a question for a labor law attorney. I work with several. I'll give you the 800 number here in a moment, and you can call me at the office during the week, and I'll set you up with one who'll talk to you free of charge to give you some options as far as recourse there, because it's a very nuanced and sort of niche practice area of law. and you certainly deserve to speak with someone who practices regularly in that field. But there's definitely going to be some good advice coming your way as far as what your options are.
Thank you so much.
Virginia, thank you for calling in. That's a fantastic question to start the show, Virginia.
Okay, take care.
Thank you. Bye-bye. All righty, you're listening to the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith. And as always, you can call in 877-943-9673. I like Virginia's question because it's a great point. Sometimes you don't have all the answers to all the questions that come in. And one of the things I learned from my mentor was it's okay to say, I don't know. And sometimes you have to say that, but our promise to you, if we don't know the answer, we'll either get with you during the week and put you in touch with an attorney that practices specifically in that particular field, or sometimes it's another type of professional, a CPA, a financial advisor, or maybe it just requires us to do some research. We'll be happy to do the research always to get you the best answer, because that's what you deserve. Not just an answer, the best answer. So that's our promise to you. 877-943-9673. Toll-free lines, open phone lines, get you and your questions right on the air. 877-943-9673. Or email me your questions, patrick@attorneypatricksmith.com. Let's go back to Tampa and talk to Arthur. Arthur, welcome to the Attorney Patrick Smith Show.
Hello, Patrick. I have a question.
Yeah, Arthur.
Hello? Can you hear me?
I can hear you just fine, Arthur.
Okay, yes. Yeah, I have a question concerning joint tenancy and common. Could you explain how those two affect intestate estates in Florida?
Fantastic question, Arthur. So when it comes did you have a follow-up, or was that your question?
I was just going to say that I'll let you answer the question. I'm just going to listen, okay?
All righty, Arthur. That sounds great. So the ways in which you can own property in the state of Florida are really fourfold. So if you've never been educated on property ownership in the great state of Florida, this is Property Ownership 101. Get your pen and pad ready, and we'll give you your education. First of all, is just solely in your name. It's pretty bland, it's pretty simple, it's pretty basic because you own the property in your name alone. When you own the property in your name alone, the legal term for that is owning the property in fee simple absolute. It means you own it completely, just yours. That's one. Number two, owning the property, tenants in common. So that means A and B own Blackacre together. And what does it mean? It means they each own what we call an undivided 1/2 interest in this property. Okay? But what happens here if A or B dies? Well, in tenants in common ownership, A's interest will pass to A's heirs. So if A dies with a will, A's undivided 1/2 interest will pass to the beneficiaries described in the will for that share of the property. Now, Arthur's specific question, what if there is no will? What if it's intestate? Well, in that particular situation, you're going to have a situation where the probate code will draft a beneficiary clause where the probate code will find an heir. So B, who's left surviving, may wind up owning half of a property with some random beneficiary of A. So there's some unpredictability there. The next way you can own property, it's abbreviated JTWROS. That stands for joint tenancy with rights of survivorship. Now, A and B still own Blackacre here, but instead of owning it tenants in common, they own it joint tenants with right of survivorship. What's the difference? The difference has to do with, well, what if A dies? Remember, in tenants in common, when A dies, A's share goes to A's heirs, either by will or by law. When it's joint tenants with rights of survivorship, A passes. A's interest passes to B as the surviving owner. So joint tenants with right of survivorship carries with it a right of survivorship to the surviving owner. Now, it's tricky, though, because under code, joint tenants with right of survivorship can be severed by either party, A or B, without the other party's knowledge and reduced to tenants in common. So you own A and B, own Blackacre together, joint tenants with right of survivorship. A does some deed without B's knowledge, and now B owns the property with some other person, tenants in common, because that was the reduction in title that occurred by A's quitclaim deed. That leads to our fourth way to own property. It's called tenants by the entireties. All 5 unities must be present for this to be the case. You must own the property under time, title, interest, possession, and marriage. Now, it's a husband and wife scenario, obviously, if marriage is present. There's a married couple. When one party passes, it all passes to the survivor. Indeed, it's a legal fiction because it's not that anything passes to that surviving spouse. Each spouse owns 100% of the property. So that means when a husband dies, wife didn't get anything. She already owned everything, but husband's interest ceased. Now, how does this differ from joint tenants with rights of survivorship? Because when it comes to severing the title, the other party's joinder is required. In other words, if you're going to sever the right of survivorship here, unlike joint tenants with rights of survivorship, where that can be done without the other party's knowledge, tenants by the entireties requires the other party to consent to that severance. So those are your 4 ways that you can own property in the great state of Florida and sort of the consequences of owning them those various different ways. So fantastic question, Arthur. Appreciate you calling in with that question. And that's Property Law 101 in Florida for everyone listening out there. If you have a legal question, 877-943-9673. Open phone lines. We will get you and your question right on the air. 877-943-9673. Open phone lines. Call in now with your legal question. And as always, you can email your questions, patrick@attorneypatricksmith.com. Again, email your questions, patrick@attorneypatricksmith.com, or call in now, 877-943-9673. That's your toll-free number to be part of our program today. All righty, next let's go to my hometown of Winter Haven, Florida, and talk to Dan. Dan, welcome to the Attorney Patrick Smith Show.
Thank you, Patrick. That was quite an answer to that question. I got lost in the middle, I think.
Well, Dan, that's the tricky part with questions like that. You sort of want to give them, like I said, the best answer, but you don't want to get too deep into it's like if someone called in with a question about the rule against perpetuities. It's like, how do you answer this question without sort of losing half your audience? So I tried my best to sort of laymanize it as best I could, Dan, but, there's only so much you can do when it gets into real property code.
Right. Okay. I have a living revocable trust, and years ago, I left a large amount of money to a church. The church has since folded, and it's no longer active. And my question is, can I make a change in my trust without having to go to an attorney or a legal person to have it notarized, or can I just do it myself?
Well, the short answer is the methodology for changing or amending your trust, Dan, is laid out in your existing trust. So to best answer that question, I would need to put eyes on your existing instrument to make certain that it is able to be changed and the methodology by which it is to be changed. Now, most trust instruments, the rule is it's amendable under the same formalities as the original creation of the document. So that's typically 2 witnesses, a notary, all signing in the presence of each other contemporaneously. So your question, could you do it on your own? Possibly, but I can't verify that for sure without putting eyes on the document. If you have an attorney, call your existing attorney, schedule an appointment, go over the document with them and say, hey, I want to know what the methodology is for changing this. What would your fee be for changing this? And then sort of go from there. But you certainly, based on the fact that you said it's a revocable trust, would have the right to change it.
Okay, thank you. Now, since the church has dissolved, would it just annul that gift that I had planned to give to them?
So 2 answers to this question. And number 1, your trust can always control for the contingencies here, Dan. It says, to First Baptist Church of whatever, and I'm just making that up, Dan. I have no idea
Yes,
which
I
church it was.
understand.
And you could say, if they're no longer in existence, then to Second Baptist Church or whatever. I mean, you can always control the contingencies there, but here's the better question, Dan. So in a lot of scenarios, we have what we call catastrophe clauses. So you'll have a family that all the family goes to one church, and the family takes a family vacation every year, so they're all on the same plane. Well, if that plane goes down, literally the entire family has entered eternity at that point. So there's no one left to inherit anything. So commonly they'll say, and if there is no survivor, then to our church. Well, what if that church is no longer in operation? You have a trustee of a trust with no beneficiaries. So what do? Now, we were talking about how we got into the deep end of the pool with real property just a few moments ago, Dan. Here we go with something called cypre. That's a French term in our trust code, which is French. Basically, it means roughly translated close enough. And what you would do is petition the court to say, Your Honor, it's impossible to carry out the grantor's intent, which is the pole star for any court on a case involving a will or a trust. What did the decedent want? So we're going to always carry out those wishes. Well, here it's impossible. All the family members are deceased, and our catastrophe clause beneficiary, the church, is no longer in existence. So the question would be, what do? Well, we petition the court to find something close enough. So if it was for instance, if it was a Catholic church, and that Catholic church is no longer in existence, maybe now it goes to the diocese. Or if it's a church, maybe their membership was assumed by another congregation, so you petition for that. But you would petition for court approval that this is the best we can do to carry out the decedent's wishes, because we would always prefer that over intestacy, which would just be random heirs selected by statutes. How was
Thank
that
you.
for the deep end of the pool, Dan? Do you feel like you need a life preserver now, Dan?
Well, I'll have to call an attorney
Yeah.
and have him look over to the beginning.
Well,
now,
if you could read it and understand it, you wouldn't need an attorney, right?
right.
Go ahead, Dan. What's
That's
your other
why I'm
question?
asking if I could change it myself and just have it notarized.
It is possible, but again, without seeing the document, I can't verify that. So I would say go to your
Okay.
existing attorney. If you don't have an existing attorney, Dan, I've got an office in Haines City. I'd be happy to meet you there and take a look at the document free of charge and let you know what I think.
Do you still have an office on 27, close to 4, where Pepin used to
So,
have an office?
no, my office is now no longer with Pippin. It's now south on 27 off 544 in Haines City.
Okay. Okay. And the name of your office?
Law offices of Patrick L. Smith.
Okay.
And the
Make an
number,
appointment to come in?
if you want to call to make an appointment, the toll-free number is 877
877
754
754.
6764.
Okay, thank you very much, Patrick. I appreciate and you're doing a good job. I enjoy listening to you.
Dan, I appreciate your kind words. How's the weather in my hometown of Winter Haven today?
It's beautiful.
All right.
We had a little rain last night, and everything is really nice.
All right, I like to hear that. Dan, enjoy Winter Haven and have a fantastic Saturday, okay?
Okay, thank you. God bless you.
God bless
Bye-bye.
you, Dan. All righty, you're listening to the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith. The number, toll-free number to call in now with your legal question, 877-943-9673. Open phone lines, wide open, get you and your question right on the air, 877-943-9673. Email your question, patrick at attorneypatricksmith.com. Again, you can email your question, and we'll go to Peter the intern here later in the show and answer some email questions, patrick at attorneypatricksmith.com. And you can call in now, open phone lines, absolutely toll free. It's just as simple as Arthur and Dan and Virginia made it look. You can call in, ask your question, and we've had some fantastic questions today. We've already gotten into labor law, real property law. We got into the doctrine of cypre, so we're really all over the place, and I love it when we get to jump around the different areas of law. So keep the good questions coming. 877-943-9673, 877-943-9673, or email Peter the Intern by emailing me, Patrick at attorneypatricksmith.com. All righty, let's go to Wesley Chapel and talk to Patty. Patty, welcome to the Attorney Patrick Smith Show.
Good morning.
Hey, Patty.
I have a family law question.
Go ahead, Patty.
If I'm getting divorced, don't I have to get divorced in the county that I reside in?
Great question. So the typical answer is it is the county of your residency. So that would be the venue for, but it is possible to have it moved. And I have a family law attorney that I work with who's of counsel with me, and I'd be happy to put you in touch with him, absolutely free of charge consultation, and I'll give you my toll-free number. You can call me on Monday, and I'll put you in touch with him and get you the best answer as far as which county would be optimal. Because does your husband reside also in the same county as you?
Yes, he did.
Okay. So, yeah, I mean, if that was the county where you resided as a married couple, that would...
And the marital home.
And the marital homes in that county as well?
Yeah.
Yeah, that would more than likely be the most appropriate county under the venue statute.
Okay, great. What would you have to do if you did it in a different county? Wouldn't you have to do something, a motion to do it? So this is post-tense, this is, past tense, but when you have to do it would they have to file a motion to do it in Hillsborough County? I live in Pasco.
That's a question I'll have you ask the family law attorney when you speak to him, as far as like procedurally. What are the steps if we want to move the venue? Because there is a protocol and a procedure to that. And I'll let them speak directly to that as far as whether or not it's even an option here, or if it is an option, whether or not it's optimal for you, Patty.
Okay, perfect. Thank you, Patrick.
All righty. Thank you, Patty. We appreciate you calling in.
All right. Take care.
Bye. All righty. You're listening to the Attorney Patrick Smith Show, and I'm your host, Attorney Patrick Smith. You can call in now. We have open phone lines, 877-943-9673, 877-943-9673. Email questions, Patrick at attorneypatricksmith.com, and we will answer those here in just a few moments. But again, the phone number to be part of today's program, 877-943-9673, and you can call in now. Open phone lines. We'll get you and your question right on the air. Now we've had our first family law question of the day, so we're going for we're almost going for the full house at this point. We're gonna cover all major legal topics today. It seems like the way the show's going. 877-943-9673, 877-943-9673, or email your question, Patrick at attorneypatricksmith.com. All righty, let's go to the fantastic, magnificent Peter the Intern for our email questions. Peter?
So the first email question today is, a friend is flying to Iceland with her boyfriend and has no will in place. Can she write a list of assets and wishes on a piece of paper that is notarized with two witnesses to be legal in Florida?
So the general rule in Florida is holographic wills, or I don't know why they call them holographic wills. No one knows what that means. They could just say handwritten. Handwritten wills are not valid under Florida code unless they meet the requirements of a will. So, in other words, states where, like, I went to law school, University of North Carolina at Chapel Hill, they actually allow you to do a holographic will. So you can write it. That's why if you go to the probate courts up in beautiful North Carolina, you will find countless bar napkins admitted to probate. Indeed, there are actual bathroom stall doors that have been stamped and logged into probate court up in North Carolina, where people have written their wills on these doors, or on a bar stool napkin, or whatever the case may be. And Florida, for whatever reason, maybe it's because they simply don't have the storage space at the courthouse, said, hey, this isn't going to work for us. So holographic wills are not going to be accepted unless they meet the requirements, which the requirements in Florida are that they're signed by the testator at the end and two witnesses. Now, in Peter's question, it was also notarized. So the better question there is, did this will meet the standard of being a self-proving will. A self-proving will is one that requires no additional proof to the court before it's admitted to probate. So if the will had the appropriate affidavit language, that may be the case. But it is possible this person may have successfully done it. Now, here's my question. So this question, I guess I have and this is the bad part about email, can't follow up. If this person did this on the plane, how did the will survive the crash? I mean, so you're telling me the plane goes down, everyone on board has passed, but somehow this handwritten will has majestically survived the crash. That's more impressive than anything. I think if I'm the presiding judge on that case, I probably say this will was meant to be probated. So that would be an interesting phenomenon. But anyway, it is possible to do your own will. If you do it, have it reviewed by an attorney. We do it free of charge. We'll review it for you, kind of give you a grade, if you will. But be very careful doing your own documents, okay? Let's 877-943-9673. That's your toll-free number to be part of our show today. 877-943-9673. Great job, Peter the intern. Keep those email questions. Give Peter the intern something to do. Keep them coming. Patrick at attorneypatricksmith.com. Let's go back to Tampa and talk to Michael. Michael, welcome to the Attorney Patrick Smith Show. How can we help you today?
Hi, Patrick. Thank you for taking my call. I sent you email on 4th of October, but I didn't get any response. That's why I'm calling the show. You going to return email, or we can talk now?
So we had some server issues over the last week, and that would explain why we lost some of the emails. So I do apologize for that, Michael. And we can talk now, or I can have you leave your number with my producer, and I can call you off the air. But yeah, we did have some technical issues with our server this last week.
Oh, okay. Maybe that's why. Well, I mean, it's a promissory note that a person started paying me back. He's a contractor, but the company is registered on his wife's name. But he's doing the job pretty much, and he stopped a renovation of my house. And I paid him a lot of money. He agreed to pay me back about $9,700. He started paying and stopped at, I think in March. That was the last payment for 5 months. And since then, he doesn't answer my emails or the phone, and it doesn't pay me any more money. And we signed that promissory note at my bank, so it's notarized. So what are my options to get my money? Because he said, the business is slow, I cannot pay you anything.
Oh, Michael, I'm so sorry you're dealing with that. And, you know, it's one of those situations I can relate to this to a certain degree, because we went through a custom build, my wife and I, for 18 to 19 months, depending on how you count. And we had an absolutely fantastic builder who did an amazing job. And we didn't realize how blessed we were with a great builder until, you know, we started hearing stories like this from people. But our builder was absolutely breathtakingly amazing and responsive and on time. And, you know, there are always delays when you build because things happen. Deliveries get delayed, whatever. But we didn't really realize how amazing our builder was until we started hearing horror stories from other parties who were also building. And Michael, it sounds like unfortunately you're in the middle of one of those cases, and I'm sorry to hear that. The short version is, if you have a written contract with your contractor, I would say go by the terms of your contract. So it's going to say, if someone defaults, then do this. Follow those rules. Have you consulted an attorney in person yet? Have they actually reviewed the contract with you and said, Michael, here are your options?
No. In fact, it's not really a contract. It's kind of like proposal that we signed. My signature and his signature is there for the whole contract, and he did just part of the things that we listed, but he wanted money in advance. So I gave him about $16,000. He did just the demolition and a little bit kind of cleaning the yard and inside, but nothing really new. He started making kind of, rebuilding the floor in one of the rooms, and that was it. And he stopped it. He said, I cannot finish that project. And I said, why didn't you tell me earlier? Because I wasted 2 years with him. So
Sorry. Well, Michael, here's my best advice. First of all, not to make an example out of you, but to everyone else listening, if you're going into some sort of build or remodel with a contractor, always protect yourself with a contract. Have it reviewed by your attorney. Understand what the pros and cons were. When we did our build, I was licking my chops because I love contracts and I love negotiating. It's one of my fortes, and I bask in that sort of stuff. And I was probably having a little bit too much fun with it. But that was probably the most enjoyable part of that building process for me, was the contract negotiation. But you've got to protect yourself with a good contract, and you're sort of suffering the consequence of not having that good contract, because typically there would be in there some sort of binding arbitration clause, attorney's fees clause, some sort of protocol establishing the venue for the dispute, something of that nature where you could hold the builder accountable more efficiently. So at the end of the day, I think the best thing for you to do, Michael, give my office a call. I'll put you in touch with our general civil litigator that we work with, and he'll talk with you about sending a demand letter. And it may be worth it first, Michael, for you to send the demand letter if you haven't already done so. Just, and again, if you get emotional about this, that's understandable. People get really upset and traumatized when things like this happen. So if you write the first version of the letter and there's a lot of emotion in it, write it and then put that letter to the side, and then write what I call the Joe Friday version of the letter. Did you ever watch Dragnet? Are you familiar with the show?
No.
Okay, this was a detective show back in the 60s, and Joe Friday was famous for saying, just the facts, ma'am. So you want to write a Joe Friday version of the letter that you're actually going to send, which is, we hired you this date for this work, and here's what's unfolded since then, and then sort of bullet point it. And then end it by saying, here's what we want, and here's when we want it by, and sort of give him an ultimatum. And send it. Probably send it certified. That way he knows you're tracking it, so you know he got it. And then if you get response to that, go to an attorney. Have the attorney send the letter and start ramping it up a notch. I think that's the best path to success that you have, Michael.
Mm-hmm. How about the promissory note? If I go like small claim court or something, I don't know how.
What's the value of the promissory note?
Well, it was originally $9,700, but now he paid me for 5 months, so it's $7,200.
Yeah, so you could bring a small claim suit, but I would recommend at least consulting with an attorney first before you bring that suit. I think it's worth the consultation, even if you don't hire counsel to represent you in the suit.
Well, I can use probably your company.
We'll be happy to give you that consultation, and if you want, I'll give you my toll-free number. You can call me on Monday.
Oh, that's good.
All right.
I'm in Tampa. Where is the office? Your office?
So we have an office right there in Tampa, and I'll give you the address. Actually, it's one of my newer offices. I actually don't have the address handy. I apologize. But if you call 877 754 6764.
Okay.
All right.
Yeah, I got it.
You just give us a call on Monday, and we will be happy to give you that Tampa address and get you an appointment there. And just make sure you bring all that paperwork with you, Michael. We'll give you a full review, okay?
Okay. All right. Will do. Thank you very much, Patrick. Enjoyed the show.
Michael, thank you. I appreciate your kind words. You have a great day, okay?
Thank you. You too.
All right. You're listening to the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith. Toll-free number to be part of today's show, 877-943-9673. Open phone lines, 877-943-9673. You can always email your question, patrick@attorneypatricksmith.com. Again, that email address, patrick@attorneypatricksmith.com, or call us now. Open phone lines. We'll get you and your question right on the air. 877-943-9673. To reach me at the office during the week, the toll-free number, 877-754-6764. and we'll be happy to get you scheduled for your complimentary consultation. 877-754-6764. But again, to call right in today and get us on the air, 877-943-9673. Currently rebuilding the website, so if you see the website's down, that's intentional, very intentional, no reason to panic. I've gotten a couple of calls and emails about that. We're currently rebuilding the website to make it better and more useful for you, our clients and fans of the show, so we're working on that rebuild and very excited about rolling that out when everything is up and running. If you, the website nonetheless, if you want to write it down, attorneypatricksmith.com. So when it's up and running, we will let you know. You can visit it, check it out, and let me know your feedback. attorneypatricksmith.com. To be part of today's show, 877-943-9673. Let's go to Sarasota, and let's talk to Susan. Susan, welcome to the Attorney Patrick Smith Show.
Oh, thank you very much. I just have a quick question. I have a power of attorney for my son. Do I need to record that at the clerk's office?
It depends. Is the power of attorney being used in some sort of real estate transaction?
It was.
Yeah.
But that real estate transaction is done.
It was probably already recorded then, and you're just not aware of it, because more than likely the title company who did the closing asked you for a copy of it. You gave it to them, and it was recorded as part of the closing papers. And if you just want to confirm that, you can pull up the records yourself, or you can call us on Monday, and we'll be happy to help you. Can just confirm that everything has been recorded.
Well, it wasn't recorded in the clerk of the court for Sarasota County.
Well, it would actually be the Register of Deeds. So check the Register of Deeds.
Yeah, I've looked that up because I kind of work in that area.
Okay.
And I have not found that. But thank you. And if I do not see it, I'm going to go ahead and spend the money and get it recorded then. Just to be safe.
Absolutely. And Susan, just since you're listening in Sarasota, what station are you listening on?
9:30.
All right.
Answer.
All right. Well, thanks for listening, Susan. We appreciate it.
Okay. Thank you for the info. Have a great day.
Yes, ma'am. Have a great day. All righty. This is the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith. 877-943-9673. Open phone lines. Call in with your legal question now. Wonderful list of questions today. Really all over the place, and I love that. Keep them coming. 877-943-9673. Email your question, patrick@attorneypatricksmith.com. And by the way, we take this show on the road. If you have a club, group, or organization out there that needs a speaker, we're available absolutely free of charge. Have an event coming up at a beautiful community in Leesburg, Florida, Monday night at the Plantation. So I'll be out there shaking some hands and doing some presentations on wills and trust and some of the new estate planning laws that have gone into effect. So if you have a group that could take advantage of that, feel free to give us a call at the office during the week, and we will be more than happy to come out and speak to your group. We actually customize presentation. Sometimes a group will want to hear a particular topic. Like I had a retired nurses group that wanted to hear a presentation on healthcare surrogacy and living wills and DNRs. So we customize a presentation just for them. So we're happy to customize a presentation for you and your group. So you can call the office during the week, 877-754-6764, 877-754-6764, and we'll be happy to schedule that speaking engagement with your group absolutely free of charge. You can also call in now to the show, 877-943-9673, or email patrick@attorneypatricksmith.com. Let's go back to Tampa and talk to William. William, welcome to the Attorney Patrick Smith Show.
Patrick, thanks so much. You know, we appreciate you and all the questions you're answering. My wife especially likes you, and she's the one that got me hooked on your show. This is a two-part question relating to one of our family members who's 86 years old. He's recently moved to Tampa from out of state and has a revocable trust. What does he need to do now with respect to the trust as he's becoming a Florida resident?
So the short answer is he should have it reviewed by a Florida attorney. And when we're reviewing an out-of-state trust, what we're reviewing it for is not for validity usually. Here's the myth, William. You hear this all the time. People say, well, my out-of-state will or trust is no good in Florida, right? Because their neighbor or someone else told them that. If the document was valid in the state of origin, it's valid here. but what we're reviewing it for is to make sure it's optimally efficient. Remember the question earlier in the show that Peter the intern read, the email question about doing your own will? So that question demonstrates this point. You can have a valid document that's not the most optimally efficient. Now, in that case, the question was whether or not that will that was holographic or handwritten, even though it met the state's requirements for a will, it may not have been self-proving. Well, if it was not self-proving, that means we're going to have to locate a witness and summon them to court. And that's sometimes the issue we face with out-of-state wills or trust, is if the document does not meet our self-proving requirements, even though it's valid, it may require that additional step of proving the document. And the other issue can be whether or not the state of origin has an aggressive Department of Revenue. So if you have a state where the Department of Revenue is super aggressive and you've got an old will or trust and the first line says, I, a resident of, and it says that old state, you're potentially giving them an unfair bite at the apple. You could easily update that for Florida just to say I'm a resident of Florida, where we have no estate tax at the state level, we have no income tax at the state level, and just streamline it. And again, notice, you're not making the document any more valid. You're just making the document more efficient and optimal for the family to get more real dollars to the intended family members as quickly and efficiently as possible. So I would say to your friend, get in with a good qualified estate planning attorney. We offer a complimentary estate planning consultation and review of those out-of-state documents where we can just sort of go over everything, answer questions, give our recommendations and a quote, and then you can go on your way from there.
Yeah, that'd be great. Yeah, we're much in favor of that. So that wasn't a question that we try to do something ourselves. We have a trust, and my wife led me on that. We have it reviewed regularly as well. The other part relates to in the event that this 86-year-old needs more care and the family's desire for him to stay in his house, his rented house, how could Medicare help? What approach should we take?
Well, I'm not really familiar on how Medicare could help, but Medicaid potentially could provide state assistance. There is a state assistance program for parties who are requiring full-time nursing care, and I work with a wonderful Medicaid planning attorney, and that's his niche, that's his practice area, and we'll be happy to give you a complimentary consultation with him. You can call the main office line on Monday, and we'll put you in touch. And he can sort of walk you through sort of what the procedures and the steps are for someone going through that particular phase of planning in their life.
Oh, that'd be great.
All right.
And did you, what number would we call to make an appointment?
The toll-free number is the easiest number, 877-754-6764.
Great, I've got that.
All right. William, we appreciate you calling in. Thank you.
Yes, sir. God bless you.
God bless you, William. 877-943-9673. That's your toll-free number. Open phone lines. Get you and your question right on the air. Email your question, patrick@attorneypatricksmith.com, or give us a call now, 877-943-9673. That's probably the most common question I get daily, is with regard to the validity of an out-of-state will or trust. So very common topic, very common appointment that I have, and we'll be happy to review your out-of-state documents with you to make sure that it's not just a valid document, but it's the best document for you and your family. All righty, let's go back to beautiful Imperial Polk County and talk to Mary in Haines City. Mary, welcome to the Attorney Patrick Smith Show.
Yes, thank you, Mr. Smith.
Yes, Mary.
Okay, my husband and I are small landlords. We have three rentals that we have. We're retired, and this was for our retirement. But along came the moratorium, and one of our tenants just didn't pay for 7.5 months. But yet they've been to Las Vegas and they bought four-wheelers and they helped the economy. But now, have I just lost that money?
I don't know. Did you have a written lease with them?
Well, the lease had expired.
So they were month-to-month tenants?
We were month-to-month, and we did evict them, but we were not able to evict them for termination.
Right.
We evicted for termination of tenancy.
Right. So you did the 15-day notice, and then you got your writ of eviction, but you couldn't serve it on them because of the moratorium.
Well, they did serve it, and they did it. He was evicted, and within 30 days we sent the required documents. But he wouldn't give us his address, so it went to the house, and then it was forwarded to a post office box. But they didn't.
Well,
we don't.
You got a deposit, correct?
Well, the deposit was long used up.
I was going to say you're way beyond the deposit if they haven't paid in 7 months. I would say, well, you got that at least. And I would just say in the future, it would be, I think a lot of leases are going to be redrafted to account for something like this, a moratorium. And I think this was just sort of unprecedented. And I think that it's going to change the face of written leases in the future for the state of Florida, because a lot of landlords felt that pinch. I've actually had that on some cases where I'm the trustee, and we had situations like that. So I understand what you're going through and the frustration that mounts with that. But we've got an attorney that we work with who's a landlord-tenant attorney, and you can give me a call at the office on Monday, and Mary, I'll be happy to put you in touch with him. He'll give you a consultation and kind of walk you through what your options are, if any. But my hunch is more than likely you're right. Let's say you even sued, you won, you got a judgment. You can't get blood from a turnip. If the money's not there, the money's not there.
Okay. All right. Well, I needed to hear that, I guess.
Mary, you're listening on WLVF?
I'm not sure what I'm listening on.
Oh.
I know you were on the radio.
That's just the hand of God, Mary. Praise God. Well, thank you for listening, Mary. I appreciate that.
All right.
All righty.
Have
a great day. All righty. You're listening to the Attorney Patrick Smith Show. A couple more callers. We're going to try to squeeze in here before the end of the show. Let's go to North Tampa and talk to Chris. Chris, welcome to the Attorney Patrick Smith Show.
Hi, sir. How you doing?
Good.
I was just calling because my mother passed away 30 days ago.
Oh, I'm so sorry.
And she had a stroke, and there was 85 days from when she had a master stroke to when she died. She was through 6 different facilities between nursing homes and back in hospitals. I really think I don't know if it'd be medical malpractice or negligence or how it would be classified. But
yeah, and I just want to tell you, there's a very fantastic personal injury firm that I work with. They're not part of my practice, but they are sort of in our circle of friends. Write this number down: 877-754-6764. Give me a call on Monday, and I'll put you in touch with them. They will give you a consultation to make certain that you know all your rights in light of your mother's death. And I will say a very special prayer for you. I'm so sorry for the loss of your mother.
Thank you. I appreciate it. But I just, from what I understand, I'm like the only person on this planet that can't sue on behalf of a parent for negligence or medical malpractice. From a news report I just happened to see on TV this morning.
Well, don't believe everything you see on the news. We'll get you in touch with a good attorney who will give you the best advice, okay?
You said that's 877?
877-754-6764.
6764.
Yes,
all right,
sir.
Thank you, Counselor. I appreciate it.
Thank you for calling in. You're in our thoughts and prayers. All righty, this is the Attorney Patrick Smith Show, and you're listening on a wide variety of stations, either 860, 570, 910, 90.3 FM. And now we are going to Charlie in Zolfo Springs in Hardee County. Charlie, welcome to the Attorney Patrick Smith Show. I have about a minute, Charlie, just so you know.
Okay, quick question. I have, my wife and I have wills and trusts, the package that was written up by Joe Pippin. And if I wanted to update those, who would I go to, or who has those files?
Joe's office is still in existence and still has his files, and you can reach out to them directly.
In Lakeland?
I believe they do still have the Lakeland office, correct.
Okay, so but it'd have to be through their office. I also have a friend that wants to write up or get a package done, and I recommended you, though I didn't have your name or number, whatever that was.
Well, my direct number, if you want to schedule an appointment or your friend wants to schedule an appointment, is 877 877-754-6764. 877-754-6764. And I do have an office there in Polk County now. And Charlie, I'm so sorry. I'm running out of time. I got to let you go, okay?
Where's your office?
In Haines City. Alrighty, this is the Attorney Patrick Smith Show. If you want to reach me during the week, 877-754-6764. Email me, patrick@attorneypatricksmith.com. God bless, stay safe, and go Gators.
The preceding was sponsored by the law offices of Patrick L. Smith. Faith Talk 570, WTBN. Odyssey. Strength between Sundays. Faith Talk.